Okay, so if you work with data, manage a team, or honestly, just use the internet these days, there's one law you really need to get your head around. The Protection of Personal Information Act, POPIA.
That's right.
We're doing a deep dive today into South Africa's big privacy framework, trying to make sense of all that legal text and turn it into something, well, usable.
It's definitely something everyone should understand, at least the basics. And I think the key thing to grasp right at the start is what POPIA is actually for. It's stated right there in the preamble.
Okay.
It's there to give real teeth to the fundamental right to privacy we have in the Constitution, Section 14.
But it's not just about locking down information, is it? Because, the economy needs data to flow.
Exactly. Privacy can't exist in a bubble. The Act itself says it needs to balance that right to privacy against other important things, like economic and social progress. We need information to move freely.
So it's a balancing act.
Precisely. POPIA sets the rules of the road for handling personal data, but it acknowledges there are justifiable reasons to process information. It's like a legislative tightrope walk for the digital age.
And getting this act in place, well, it took a while. Looking at the sources, it was signed into law back in 2013.
Yeah, assented to then.
But the really important bits, the core rules for processing data, they only kicked in properly on July 1st, 2020.
That's right. And even then, parts were phased in, like the specific rule about notifying everyone after a data breach, Section 582, dealing with security compromises that only became fully effective for existing processing in February 2022.
So it's been an evolution.
Definitely. It shows you need to keep on top of it. Compliance isn't a one-off thing.
Right. So our mission today is really to unpack how this thing is structured. We want to focus on the absolute minimum requirements for lawfully processing data and maybe flag some of the high-risk areas where things can go badly wrong for organizations.
It sounds good.
Let's start with the players. Who's who in the world of POPIA?
Okay, so there are three main roles you need to know. First, and most importantly, is the data subject.
That's the person the information is about.
Yes, the individual. But, and this is really critical and a bit unique to POPIA, it's not just a living person. It can also be an identifiable existing juristic person.
A company.
Exactly. A company or another organization. Oh. Their personal information is also protected under POPIA.
Wow, okay. That's huge. So a data breach could expose another company's sensitive info, not just an individual's. That's a massive risk.
It absolutely is. And the type of information covered, the personal information, is defined so broadly. It's not just your name, address, race, health stuff, financial details.
It's your usual suspects.
Right. It also explicitly includes things like biometric information, fingerprints, retinal scans, unique identifiers like your ID number or even, say, a customer number, personal opinions about the person, even the content of private correspondence. Basically, if it could be linked back to an identifiable person or company, it's likely covered.
Okay, that net is cast very wide. So who's handling all this data?
Well, you have the responsible party. This is the organization, public or private, that decides why the information is being processed and how it will be processed. They're the ones calling the shots on the purpose.
The decision maker.
Correct. Then, if that responsible party hires someone else, maybe a vendor, to actually do the processing for them.
Like a payroll company or a cloud storage provider.
Exactly. That third party is called the operator. They process the data on behalf of the responsible party, following their instructions under a contract or mandate. The key thing is the operator doesn't decide the purpose. They just execute.
Got it. Now, how far does this act reach? Is it just for data physically sitting on a server in South Africa? What if I use, I don't know, Google Cloud or AWS servers overseas?
POPIA's reach is pretty broad. It applies to the processing of personal information by automated means, think software, databases, and also non-automated means, like paper records, if those records are part of a structured filing system. And it applies if the responsible party is domiciled in South Africa, basically based here. Or, importantly, even if they aren't based here, if they use automated or non-automated means within South Africa to process the information. So using a local server or even local staff could trigger it.
Right, so that offshore cloud provider point isn't a simple escape route. But are there areas where POPIA doesn't apply? Any exceptions?
Yes, there are some key exclusions. It doesn't apply to processing data for purely personal or household activities. So, your personal contact list or home budget spreadsheet is fine.
Yeah.
Also, data that's been properly de-identified, meaning it can't be linked back to someone, and importantly, cannot be re-identified later. That's out. Then there are exclusions for things like national security, defense, the functions of a court, and a significant one for journalism, art, or literature.
Ah, the media exemption.
Yes, but only where processing is solely for those purposes, and the exemption is necessary to balance the right to privacy with freedom of expression. It's not a blanket pass.
Okay, that makes sense. Let's dig into the core compliance part then. Chapter 3 lays out the 8 conditions for lawful processing. These sound like the real heart of the act.
They absolutely are. Think of them as the minimum standards, the sort of baseline requirements that must be met whenever you process personal information. They cover the whole data life cycle.
Condition 1.
Accountability, Section 8. It sounds simple, but it's fundamental. The responsible party is ultimately responsible for ensuring that all the conditions are complied with, right from the moment they decide why and how they're going to process the data. The buck stops with them.
Makes sense. Condition 2.
Processing limitation, Sections 9 to 12. So it's got a few key parts. First, processing must be lawful and reasonable, and importantly, it must align with the principle of minimality.
Minimality, meaning collect only what you absolutely need.
Precisely. The information must be adequate, relevant, and not excessive for the specific purpose you collected it for. No over-collecting just in case.
And lawful part, how do you justify processing?
This is crucial. Generally, you need a lawful basis. The most well-known one is consent.
Getting the person's permission.
Yes, but it has to be proper consent, voluntary, specific, and informed. The person needs to know what they're agreeing to. But consent isn't the only way.
Oh.
No, processing is also lawful if it's necessary to carry out a contract with the data subject, like processing employee details for payroll as part of an employment contract,
Okay.
or if it's required by law visiting tax obligations, or if it's necessary to protect the legitimate interest of the data subject, or, and this is a big one, if it's necessary for pursuing the legitimate interests of the responsible party or a third party to whom the information is supplied.
So consent is ideal, but not always required if there's another solid legal reason, like a contract or a legal duty.
Exactly. And often, relying on a basis like performance of contract is more practical for day-to-day business operations than constantly seeking fresh consent.
Right. Conditions 3 and 4 seem linked. Purpose specification and further processing limitation.
They are. Condition 3, purpose specification, Section 13, says you must collect data for a specific, explicitly defined, and lawful purpose related to the functions or activities of the responsible party. You have to be clear about why you need it up front.
And condition 4.
Further processing limitation, Section 15. This stops you from reusing the data later for something completely different and incompatible with that original purpose.
So if I collected email addresses for, say, sending warranty updates.
You generally can't just decide later to sell that list to a third-party marketing company for totally unrelated products. The further processing must be compatible with the original reason for collection.
Unless. There are always exceptions, right?
There are. For example, if the data subject consents to the new purpose, or if the information is already public record, or if it's used for historical, statistical, or research purposes, but crucially, only if it's done in a way that doesn't identify the individual.
Okay. The other conditions, 5 and 6, seem more about process information quality, openness, keeping data accurate, telling people what you're doing with their data.
That's right. Essential operational stuff, making sure data is complete and accurate, Condition 5, and being transparent about your processing activities, Condition 6, like having a privacy notice.
Let's jump to condition 7 then, because this feels like where things often go publicly wrong. Security safeguards.
Ah, yes. Section 19. This is absolutely critical.
So what does it actually demand? Just having antivirus software?
Oh, no, it's much more than that. Section 19 requires the responsible party to secure the integrity and confidentiality of personal information by taking appropriate, reasonable technical and organizational measures.
Okay, appropriate and reasonable sound a bit vague.
They are, deliberately so, because what's reasonable depends on the context, the sensitivity of the data, the resources of the organization, the nature of the risks. But the Act clarifies. You need to identify all reasonably foreseeable internal and external risks, establish and maintain appropriate safeguards against those risks, and regularly verify that the safeguards are effective and keep them updated.
So it's an ongoing process of risk assessment and mitigation.
Absolutely. Yeah. And then there's the nightmare scenario, when those safeguards fail. That brings us to the notification duty under Section 22.
The data breach notification.
Exactly. If there are reasonable grounds to believe that personal information has been accessed or acquired by any unauthorized person, a security compromise, the responsible party must notify the Information Regulator.
And the data subjects, too, the people affected.
Yes, and the affected data subjects. This has to happen as soon as reasonably possible after discovering the compromise. The only real excuse for delay is if law enforcement or the regulator asks you to hold off because notification would impede a criminal investigation. Otherwise, you notify.
That sounds intense. Okay, beyond the general conditions, POPIA flags certain types of data as needing extra care. Let's talk special personal information.
Right, Section 26. This is data considered particularly sensitive, and processing it is generally prohibited.
What falls into this category?
It includes information about religious or philosophical beliefs, race or ethnic origin, trade union membership, political persuasion, health or sex life, biometric information, and importantly, alleged criminal behavior or proceedings.
So you just can't process that stuff.
Not unless specific conditions are met. There are authorizations, for example, if the data subject explicitly consents, or if it's necessary for legal claims, or, say, for specific functions like health professionals processing health data for patient care, or trade unions processing member data relevant to their activities. But the default position is prohibition.
Got it. Another high-risk group. Children.
Yes, processing of children's information,
Yeah.
Sections 34, 35. POPIA puts strict limits here. There's a general prohibition on processing personal information concerning a child, unless you have prior consent from a competent person, which usually means a parent or legal guardian, or if it's necessary for legal proceedings involving the child, or if it's for historical or statistical purposes in a non-identifiable way. The regulator can also authorize processing, but they might impose conditions, like ensuring you don't try to unduly encourage a child to disclose more information than necessary.
Makes sense. What about data leaving the country? We mentioned cloud providers earlier. Transborder information flows.
Section 72. This is a big one, especially in a globalized world. You generally cannot transfer personal information about a data subject to a third party in a foreign country unless certain conditions are met.
Such as?
The main one is that the recipient country or organization must be subject to laws, binding corporate rules, or a binding agreement which provides an adequate level of protection for personal information.
Adequate. How is that defined? Does it have to be identical to POPIA?
It needs to be substantially similar to the principles and conditions in POPIA. Essentially, the data needs the same level of protection abroad as it gets in South Africa. Proving adequacy can be complex.
So I can't just use any cheap overseas hosting. I need to check their country's laws or the company's own rules.
Pretty much. You need to do your due diligence.
Mm-hmm.
Other grounds exist, like the data subject consenting to the transfer after being informed of the risks, or if the transfer is necessary for performing a contract between the data subject and the responsible party, or a contract in the interest of the data subject. But the adequacy requirement is the default hurdle.
Okay, this next one probably affects almost everyone listening. Your rights against unsolicited marketing. Spam texts, spam emails.
Ah, yes. Section 69 deals with direct marketing by means of unsolicited electronic communications.
So can companies just blast out marketing emails and SMSs?
Generally, no. Processing personal information for direct marketing using automated calling machines, fax, SMS, or email is prohibited unless one of two conditions is met.
Okay, what are they?
Either the data subject has given their prior consent, or, and this is the key exception, the data subject is an existing customer of the responsible party.
Ah, the customer relationship.
Yes, but even that has strict rules. 1, you must have obtained their contact details in the context of a sale of your own product or service. 2, the marketing can only be for your own similar products or services.
So if I bought shoes from you, you can market other shoes or maybe socks, but not insurance.
Exactly. And 3, crucially, the customer must have been given a reasonable opportunity to object to the use of their details free of charge and in an easy way, both at the time the information was collected and on every single marketing communication sent afterwards. That unsubscribe link has to be there and work.
Right, the opt-out. Finally, in this section on rights, what about decisions made purely by machines? Automated decision-making.
Section 71. This gives you the right not to be subject to a decision which results in legal consequences for you or significantly affects you if that decision is based solely on automated processing of your personal information intended to profile you.
So, like, an algorithm automatically rejecting my loan application or job application without any human review.
Precisely. You can't have decisions with significant impact made only by a machine based on profiling.
Are there exceptions?
Yes. It's allowed if the decision is taken in connection with concluding or performing a contract, provided that the automated decision is allowed by law, or you've given consent, and crucially, Suitable measures are in place to allow you to make representations about the decision. You need a mechanism to challenge the machine and request human intervention. You also have the right to be informed about the logic behind the automated decision-making.
Okay, transparency and a right to appeal, essentially. Now, who makes sure all these rules are followed? The Information Regulator.
Correct. Established by Section 39 of the Act, it's an independent body designed to be free from undue influence, and it's accountable to the National Assembly.
And it wears two hats, right?
It does. It oversees compliance with POPIA, protecting personal information, but it also oversees the Promotion of Access to Information Act, PAIA, which is about transparency and accessing records held by public and private bodies. So privacy and access handled by the same regulator.
And within organizations, who's the point person for POPIA?
That's the information officer, required by Section 55. Every responsible party has to designate one, usually someone at management level by default, like the CEO for a private company. Their job is to encourage compliance, deal with data subject requests, work with the regulator on investigations, and generally be the internal champion for data protection.
The internal gatekeeper. So what happens when things go wrong? When organizations don't comply, what are the consequences?
Well, there's a range of enforcement tools and penalties. The regulator can investigate complaints, conduct assessments, and issue information notices demanding information, or enforcement notices ordering specific actions to stop or start doing something.
Like stop processing this data unlawfully or implement better security.
Exactly. And if those aren't complied with, things can escalate. There are really three main levels of pain for noncompliance.
Okay, level 1.
Civil remedies, Section 99. This means the data subject themselves, or the regulator acting on their behalf, can sue the responsible party in court for damages caused by a breach of POPIA.
Damages like financial loss.
Yes, for patrimonial loss, actual financial harm, and non-patrimonial loss, like distress or injury to feelings. The court can also award aggravated damages. And critically, liability here can be imposed even if the responsible party wasn't negligent or didn't intend to breach the act. It's potentially a strict liability situation.
Wow, okay. Strict liability, that's serious. Level 2.
Criminal offenses. Section 107 lists several actions that are actual crimes under POPIA. Things like obstructing the regulator, failing to comply with an enforcement notice, or unlawfully obtaining or disclosing sensitive account numbers.
And the penalties?
They vary. For the most serious offenses, like messing with account numbers or obstructing the regulator in certain ways, the penalty can be a fine or imprisonment for up to 10 years. For lesser offenses, like non-compliance with notices, it could be up to 12 months imprisonment or a fine.
So jail time is possible. And level 3?
Administrative fines. This is a big stick the regulator wields directly, under Section 109. They don't need to go through the criminal courts. The Enforcement Committee can impose fines on a responsible party for serious breaches of the conditions for lawful processing.
How big can these fines be?
The maximum is currently $10 million per incident. The actual amount depends on various factors evaluated by the regulator. The nature of the breach, how long it lasted, how many people were affected, whether it was intentional or negligent, any history of previous failures, and importantly, whether the infringement raises issues of public importance.
Are 10 million. Okay, that definitely gets the boardroom's attention.
It certainly should.
So pulling it all together, POPIA really has created this comprehensive system in South Africa. It demands ongoing documented accountability from pretty much anyone handling personal information.
Absolutely. It aligns South Africa with international data protection standards like GDPR in many respects.
And understanding it, these 8 conditions, the rights people have, the different types of data, and especially those serious consequences for getting it wrong, it's just not optional anymore, whether you're, studying law or running a business.
It's foundational knowledge now, but it's not static. The Act itself sets up challenges. For instance, that requirement for adequate protection for transborder data flows.
Section 72.
Yes. Defining adequate when technology and laws in other countries are constantly changing is a huge ongoing task for the regulator. How do you ensure POPIA keeps pace with global standards, especially when you're trying to balance that protection with the need for information to flow freely and when our definition of personal information is already so incredibly broad?
That's a really interesting point. How do you keep a national law like POPIA truly harmonized in a fast-moving global data landscape?
That's the $1 million or maybe our 10 million question for the regulator and for every organization trying to comply in the years ahead. It's something everyone needs to keep watching.
A complex challenge indeed. Well, that's all the time we have for this deep dive into POPIA. Thanks for listening. We'll catch you next time.